This video examines the gradual removal of courts in Ontario, shifting from inherent jurisdiction to digital systems. The core message is that you do not lose rights first. You lose the court that enforces them. The original foundation of the justice system includes superior courts of inherent jurisdiction, English common law, and the preamble to the Constitution Act, 1867. These constitutional courts are not created by statute. Part 2 of the original foundation emphasizes protecting life, liberty, and property, along with due process and open justice. Fundamental rights are pre-existing and are not granted by the government. The constitutional structure dictates that criminal law is federal under Section 91(27), and judges are federally appointed under Section 96. Courts are constitutional and judges remain independent. The role of provinces is limited by Section 92(14) to administer justice, maintain courts, and set procedure. Provinces cannot replace constitutional courts or substitute their function. A constitutionally valid operation requires independent courts, full hearings, proper trial structure, and safeguards. The state must follow this structure. In the court structure, the judge represents the law, and the jury represents the community. The Conway case of 1902 demonstrated that detention without a jury results in habeas corpus and immediate release. The state must follow the proper structure. The rule is that denial of the proper structure invalidates the entire process. The case collapses, and any detention is deemed unlawful. This proves that the structure is mandatory, and the jury is essential. If the structure is violated, the case collapses, demonstrating that rights are enforced through this mandatory structure. The modern shift, beginning around 1989, introduced the Ontario Court of Justice, a statutory court with limited jurisdiction focused on high-volume processing. The 95% reality shows that the vast majority of cases stay in provincial courts. Less than 5% reach the superior courts, which provide access to a jury. This shift means that most cases have no access to a jury or a constitutional court. For many, the lower court effectively becomes the final court. In statutory courts, proceedings are limited only to the criminal code and statutory rules. There is no judicial discretion. The focus is strictly on following the letter of the law. When common law and the Bill of Rights are involved, they are often not heard or are ignored in statutory courts, and the process continues regardless. At the municipal level in Ottawa, courts have been removed and replaced by the Administrative Penalty System, or APS. The Administrative Penalty System, or APS, means no court, no judge, no hearing, and no due process. It is simply about applying penalties. This represents a profound shift. Before, there were superior courts, a jury, and full rights. Now, statutory courts dominate, and rights are often ignored. The introduction of digital systems leads to online decisions and automated processing. There are no live hearings, as the hearing process has been removed entirely. This progression illustrates a path where courts are bypassed, hearings are removed, and a decision system takes over the process. In the comparative model of China, only 1% of cases go to trial, permission is required, and there is a 1% acquittal rate. The outcome is controlled. The final conclusion is that courts and rights exist on paper, but most never actually reach them to enforce their rights. The final line: you do not lose rights first. You lose the court that enforces them. Therefore, awareness must become action to address this issue.